Okay, we have, I think, both counsel here for the third matter. Okay, Mr. Saval, did I pronounce that correctly?
Yes, Your Honor. Good morning.
Thank you. Did you wish to reserve any time for rebuttal on this matter that we are doing now, which is Winca and Wilmington Savings Fund Society?
Yes, Your Honor. I'd like to request to reserve 5 minutes.
Okay, I have made that notation. I will do my utmost to let you know either just before or at that moment when you are there, so you can make a strategic decision to invade or not to invade the corpus of your remaining time.
Very well, Your Honor.
What is going off here? I thought I turned off my phone. Sorry, glad it came before anyone started. We are ready to begin, counsel.
Thank you, Your Honor. May it please the court, my name is Sean Saval and I represent the appellant, John Winca, in this matter. And the issue before the court is the application of Florida Rule of Judicial Administration 2.505, subsection F, concerning withdrawal of counsel. And the appellant had a prior counsel who was disbarred or suspended permanently and later disbarred during the course of the prior counsel's representation. And the Rule 2.505F has 4 tenets of when an attorney may withdraw during representation. Either withdrawal, substitution, termination of the proceeding, and a narrow provision of filing a notice of completion in a family law.
So let me ask you a question, because 20 minutes goes by really fast. You'll learn that. So we've all read this, and I don't mean to cut you off. I'm sure your presentation's great, but let me just ask this. Whose responsibility was it to notify Mr. Winca of Mr. Stopa's order from the Florida Supreme Court to cease representing clients dated July 27th, 2018. He had 30 days to cease representing clients, which means by August 27th, 2018, he was not to represent anyone. Whose responsibility was that to notify Mr. Winca?
Judge, that was Mr. Stopa's representative.
Okay, so it's not the bank's. Okay, so we've established that. The bank filed their notice of non-compliance September 27, 2018, which is 30 days after Mr. Stopa is supposed to be not representing anybody at all. So I guess we'll assume Stopa did not notify Mr. Winca, but the notice did go to the property address.
It did not.
In accordance with everything. Yes, it did, sir. It went to the property address. It may not have been named to Mr. Winca, but it went to the same address that it's gone to ever since. And that would be the Spencer Circle. 6819 Spencer Circle is the address every notice went to, whether it had Winca's name on it or not, but it did have Winca's name on it 1, 2, 3, 4, 5 subsequent to that hearing. And in your brief and in your argument, you can see that Mr. Winca got mail, but you make this argument that it's not reasonable for him to expect to receive notices from the bank, or it's not reasonable for him to open mail because he doesn't recognize the law firm. So
Yes, Your Honor.
If it's Mr. Stopa's fault for doing that, and the bank files this and files the notice of hearing to the property address, what else are they supposed to do?
Your Honor, the argument isn't intended to place blame, or ultimately the issue is whether or not Mr. Winca had notice of his counsel's impending ultimately termination from his representation.
Well, that's between your client and Mr. Stopa. We've already decided that. So the court is presented with a motion that has a copy of a Florida Supreme Court order saying as of August 27, 2018, he's not representing anybody. So 2.505, I appreciate that, but 2.505 does not cover that. So the court is looking at a motion where the Florida Supreme Court says you are no longer a lawyer as of 8/27/2018. So the court grants it and gives him Mr. Winka 20 days to get the lawyer. And the bank even asked, can we communicate with him directly since Mr. Stopa can no longer practice law? How's that a violation of the rules of judicial administration, given these exceptional circumstances where it is somebody else's fault over which the bank has no control?
Well, Your Honor, the purpose of Rule 2.505 is
I know the
clearly due
purpose,
process.
but you've already just told us that Mr. Stopa was responsible to do it, and the bank has no control over him.
Well, ultimately, he had no. He stated in his verified motion that he was not aware of the termination or suspension. So if he did not have notice,
yeah, but you're intimating that it's the bank's responsibility to do that, when you've just agreed with me it was Stopa's.
I don't think it's a matter of blame shifting. It's an issue of whether or not he had notice,
But notice of the suspension. He had notice of the hearing and went to his house.
Well, one issue is that the defendant, Mr. Wenka, was not personally served. He was substitute served. There's no evidence that he was that was even a proper address, and that's one of the requirements of 2.5.
Yeah, but he hasn't sworn in his motion that that's not his address. The only thing that he swore to was he was never furnished with a copy of suspension, 1, and 2, that the notice of non-compliance wasn't given to him. He doesn't say he wasn't served. It says it wasn't given to him, which that's not required by law. You don't have to hand deliver it.
Well, Your Honor, I think that it's ultimately intertwined that he did not have notice of the suspension. So I think that's a distinction without a difference, that he did not know that he was not represented throughout the proceedings until after.
But how can you impute a violation of due process on the bank if it wasn't the bank's responsibility to notify him of his lawyer's purported disbarment?
I don't think we're placing the onus on the bank to notify him, but when the court looks at whether there was notice of the termination under 2.505 as counsel, that there was not notice, and that's what makes that in lack due process.
But the notice of non-compliance attached the notice of his suspension, and it went to Mr. Winka's home address.
And it was not addressed to Mr. Wenka.
Still went to his house.
Your Honor, I don't think it's reasonable to expect that mail to someone's house that is not addressed to them would be sufficient notice to that person, that he was somehow expected to open mail not addressed to him. So there's also the issue of the identity of who was sending the notice, being a law firm and plaintiff that were basically two plaintiffs' firms and two plaintiffs removed from the initial plaintiff that filed and brought this matter. So that issue means that even if Mr. Wenka saw that mail come in to his house, he would not recognize it and there wouldn't be the expectation for him to open that mail going to his house.
Yeah, but he didn't swear to that, sir. You're just making argument. To make a colorable claim, the case law is pretty clear. You need an affidavit. You need some sort of sworn allegation, and I've already told you what his allegations were. He never said in his motion to strike or set aside the verified. He never swore that he didn't recognize the mail or who it was from. That's an argument, so that's not evidence.
Well, Your Honor, whether or not those notices went to him, ultimately, we do know that he was still under the impression that he was represented by an attorney. So whether or not those notices made it to him and he was aware is beside the point, because a represented party does not assume the obligation to appear for proceedings that he assumes his attorney is representing him on. And that is the Moss versus State Farm case out of the 4th District, 1976.
So the order granting the notice of noncompliance dated November 20th, 2018 was sent to John D. Winka at the property address. So that's November 20th, 2018. He then files the motion that he never knew about any of this until July 3rd of 2019, 8 months later.
That's correct, Your Honor. That was a sworn statement in his verified motion. And if it was uncontradicted by the appellee, and if the court questioned the veracity, I believe it was appropriate to hold an evidentiary hearing to determine whether Mr. Wenke did in fact have reason to know about his suspension prior to that motion. But that was not done. Instead, the motion to set aside was summarily denied.
Was there anything in Mr. Wenka's verified motion to set aside the foreclosure sale that addresses the order that tells him he has 20 days to obtain new counsel? Did he attest under oath that it was never received at that residence, that he never saw it, that he elected not to open it? Did he address it in any manner whatsoever?
Not directly, Your Honor, only by virtue of the statement that he was not aware of his counsel's suspension and termination.
But under what 1.540, which was his traveling motion, he would have to show what, some form of excusable neglect?
If under subsection 1, that's correct, Your Honor. However, under subsection 4, which I believe is correct in interpreting Rule of Judicial Administration 2.505, the case law, albeit limited, states that it is fundamental error on its face.
Fundamental error does not necessarily, as I understand in some of the matters in criminal law, doesn't necessarily entitle one to relief. It entitles you to consideration in the absence of an objection or preservation. I think in some areas one still has to show what prejudice one has shown. Now, I don't know if all those rules transfer over in the same manner to a civil proceeding, but why would fundamental error, as distinguished from, say, a structural error in like Arizona fulminante, where you're denied a right to a jury trial, why would that automatically entitle you to relief?
Your Honor, I think it ultimately comes down to due process underpinning to Rule 2.505.
That's part of my concern. If you have been notified by the court and you have decided you don't want to know for whatever reason what's going on, and there was process was given by the judge. Notice was given. It was sent arguably on to the client. I think there's arguably a presumption of mailing under the law, and there's no refutation in his affidavit that says the first time I saw it was when my lawyer told me it was in the record. I mean, I'm concerned by this omission and what inference the trial court could take from that omission.
Well, Your Honor, I don't think it's accurate to say that the notice was sent by the court. All the notices were sent by the plaintiff's law firm. I don't know if that's a.
I don't know what the record tells us, who prepared the envelope with the stamp, or whether it was sent by electronic mail, or whether it was both electronic and snail mail. I'd have to go back and check the record. I don't remember it right off the top of my head. I'm sorry, I can't. I don't remember it. I want to ask you to respond to something I can't recall.
Your Honor, I do believe that to be the case is that all of the notices and motions were sent by the plaintiff through their counsel and not from the court.
Well, I'm not so sure that makes a difference, because on April 29, 1919, the plaintiff's motion for summary judgment was served on John D. Winka at his home address. On May 3rd, 2019, the notice of hearing of the motion for summary judgment was served on John D. Winka at his property address. He never mentioned that in his verified motion to set aside that he did not receive that.
Counsel, I shall respond to the inquiry. I'll let you know that after that, you will be invading the 5 minutes left, because we're right at 15 now.
Well, I would just respond to Judge Sleet that I don't think that is reflected in the record.
Okay.
I'm sorry, what's not reflected?
Or in the motion, to the verified motion.
Right, because don't tell me these weren't sent to the property address, because I have these copies in my hand.
That was not my intention, Your Honor. I apologize for any proper inference.
Thank you, Mr. Spall. Did you wish to reserve the remaining of your time for rebuttal?
I do. Thank you, Judge.
Thank you, counsel. All right, let me do I have to control the stopwatch here, so you bear with me as I lack all types of skills here. Counsel, Ms. Manganelli, it is your opportunity to respond.
Thank you, Your Honor. And for the record, Melissa Manganelli from Mandel, Manganelli and Leiter, representing the appellee in this case. Your Honors, I agree with what Your Honors have been saying. In this case, the plaintiff, and the appellee, the bank, who I represent, had no responsibility to notify Mr. Wenka of what happened with his former counsel, who was permanently.
Well, let me pose you this question.
Yes.
Your counsel filed the motion to sever the appellant's attorney-client relationship. Is that correct?
Well, Your Honor, I believe, in a way, I guess you could characterize it as that.
And did you provide, when you're interfering with that relationship, did you provide notice by a copy to the appellant?
We did not provide notice of we did not initially, Your Honor, because
So
we
in the past, the law tends to favor attorney-client relationships. And it seems as the movement, you have the burden of persuasion and maybe also the burden of notice when you are interfering with relationships. So I'm not yet persuaded one way or the other, but I'm not so sure that pardon the phrase, it's clear.
I understand, Your Honor.
Okay.
Your Honor, in this case, we were in as I was saying, in a catch-22, because technically Mr. Wenka was still represented by Mr. Stopa. We were not in a position to directly reach out to him, even though the Florida bar had made it clear that Mr. Stopa was permanently suspended. So really, we noticed it for a hearing. We noticed Mr. Stopa for the hearing. Immediately following the hearing, Mr. Wenka was served with a copy of the order, making it clear that Mr. Stopa was stricken as his counsel and that he had time to retain counsel. And Your Honor, I think it's important to distinguish a lot of the cases that were cited in appellant's briefs, in that, in a lot of these cases, there's a motion to withdraw, and then there's a concern about the client's rights and preservation of those rights when they're immediately going to trial or going to trial in 2 weeks. That's not what happened here, Your Honor. And this case is very distinguishable from those cases in that this case went on for another 6 months before we proceeded to our motion for summary judgment. And in essence, Your Honor, this case was a 2012 case. It was lingering for 7 years. And that whole process with Mr. Stopa getting permanently disbarred was not an overnight process either, Your Honor. That took quite some time as well. So in essence, Your Honors, appellant is arguing that once a client retains counsel, that they completely can just forget about their case, that there's absolutely no duty on their part to reach out to their counsel to find out, gee, what's going on? How are things going? What's going on with my case? And if such was the case, Your Honor, I believe it follows that courts would never allow counsel to withdraw based on their inability to reach a client, which, as we all know, in the real world, that happens all the time. So, Your Honor, I just feel like it's unreasonable to place an additional burden on the appellee in this case.
Let's assume for the purposes of the next question, and I'm not asking you to concede, I'm just asking you to assume. Let's assume for the first part that there was a notice problem and it's might be an error. My concern is what prejudice under Rule 1.540 or any requirements of that rule has Mr. Wenka established that would entitle him to either A, an evidentiary hearing, or B, a result automatically. I'm not concerned. I'm not sure about that point because I'm concerned that when you have been given notice and the court has done what it can to send you an order to provide you notice to get counsel, I'm not sure a party can then just claim, I'm not going to do something, I'm not going to look, I'm going to be, what's the phrase, like an ostrich with my head under the ground, and therefore, please grant me relief. And I'm simplifying it for the purposes of the analysis, saying, assume the first part was met, but do they try, is there any success under 1.540?
Your Honor, I don't believe so. And that's an interesting point you bring up because interestingly, the appellant indicates that the first date that he became aware of his counsel's disbarment was that July 3rd, 2019 date, which is the same exact day of the judicial sale. So, Your Honor, that's extremely hard to believe. And
without an evidentiary hearing, I don't know what the trial court would have believed.
Well, he swore under oath. And actually, Your Honor, and getting to my point is, Mr. Wenka requested an evidentiary hearing on the issue of when he first became aware of his prior counsel's suspension. And Your Honor, he actually already informed the lower court of when he first became aware of that. He indicated that he, in his sworn pleadings, that the day that he found out was July 3rd of 2019, which was the day of the judicial sale. So if he already informed the court that that was the first day that he became aware, there was no reason for the lower court to have an evidentiary hearing on that issue because the lower court already knew that was the date that he first found out.
That would be paragraph 14 of his motion?
Yes, I believe so, Your Honor, yes.
Yes, okay.
So, I mean, Your Honor, I think it was a pretty open and shut case. The court looked at his statements and his sworn motion, and then he asks for an evidentiary hearing on when he first became aware, but they already knew when he first became aware because he indicated to them when he first became aware. So there was really no reason to have an evidentiary hearing on that issue. And Your Honor, under 1.540, he needed to allege excusable neglect, and I don't believe he did that in this case. Your Honor, and the court needed to use a reasonable test as to whether or not there was excusable neglect here. The appellant swore under oath that he received periodic updates from Mr. Stopa's office and assumed there were no updates which required his attention. However, 6 months had elapsed. Is that reasonable not for him to follow up with his counsel? I would say no, Your Honor. And received numerous notices from the court and from appellee. Was that reasonable to ignore all those notices? As the Honorable Sleet indicated, there were at least 7 or 8 notices that were sent to Mr. Wenka at the property address. In his affidavit, he never said he didn't receive notices. He never alleged that he didn't live at that property address. as Your Honor indicated, it sounds like he just chose to dig his head in the sand, but that is not excusable neglect, Your Honor.
In paragraph 15, he says, without the benefit of notice that his counsel have been stricken, my reading of the judge's order says defendant has 20 days to obtain new counsel, and the statement of certificate on the back page of the order or the next page lists Mr. Winkin's address. So that seems to be that there was notice provided, at least under presumption of mailing. So again, I'm concerned about a number of the issues, even under 1.540, whether there's been a demonstration of entitlement to an evidentiary hearing. I mean, that's
I would
why
agree, Your Honor.
that's why we're having argument, right?
Yes.
You
Your
still
Honor,
have a lot of time left, so don't worry.
I really don't have anything else to add other than what we've already discussed and what's in the briefs. If Your Honors have any additional questions for me, if not, then I really don't have anything else to add. I don't want to take up too much of your time today.
Thank you, counsel. Mr. Saval, you have some time remaining for rebuttal.
Thank you, Your Honor.
5 minutes, if you would.
Well, one thing that counsel for the appellee brought up was, and Your Honor brought up, was excusable neglect, but excusable neglect is only required under 1.540B1.
What case are you relying on to believe that if there is in fact a fundamental error, it automatically entitles the moving party to relief? Where would I find support for that proposition rather than an establishment of some sort of harm, a legal harm?
I'm relying on Cottrell versus Taylor Bean Whitaker Mortgage. That's 198 Southern 3rd 688, which is this course was rendered by this court in 2016.
I believe I read that. I think, okay, thank you. I got it. I'll take a look at it.
Thank you, Your Honor.
Mr. Saval, let me just ask you, because I just noticed again, I've had it circled here, but the order on plaintiff's notice of noncompliance, which gives Mr. Winka 20 days to obtain new counsel, appears to have been mailed to the property address twice, one to John D. Winka and one to unknown occupant, now known as Rick Collins. So 2 notices went to the property address that day. The verified motion does not address that in any way. This is in the court file. It's a verified motion. You're trying to show a colorable claim. Now, the defense or the bank in this particular case responded to the verified motion with all of the dates and how service was provided. Why are you entitled to a hearing if it appears from the record itself that the court can resolve this?
Well, Your Honor, the main point is that Mr. Winka wasn't given notice of the hearing where his counsel was stricken. And the cases interpreting Rule 2.505F say that alone entitles the aggrieved party to relief. The cases that I'm referring to, and there are not a lot of them, is Agate Charter Schools versus Summit, which is a 5th DCA case from 2018. Garden v. Garden, which is a case from 2002 from this court. And Sens v. Pena, a 3rd DCA case from 2000, which interpreted the Rule 2.060J rule prior to renumbering. And these cases say that the failure to of a voluntarily withdrawing attorney, those requirements are to provide notice and notice and the motion to the represented party that there is.
Yeah, but in Garden, it's clear in the first sentence in Garden's counsel moved to continue, it was denied, and then the court permitted him to withdraw at the same time without notifying the client. This isn't the case here at all.
Well, related to that, another case also saying that the failure to comply with 2.505 is Calderon versus Seminole County Sheriff. And in that case, the motion to withdraw did not comply with Rule 2.505 because it failed to set forth the client's last known address. And that fact is not presented other than the property address in the record. But we know that is not part of the notice of noncompliance, which in this case served as the motion to essentially the motion to withdraw due to Mr. Stopa's failure to comply with the Supreme Court's order. But I think that to Judge Sleet, to your earlier point, the fact stated under oath in the motion to set aside final judgment by Mr. Wenka stated that he did not have knowledge of his attorney's suspension until July 3rd, 2019. So there's no way he could have received the order notifying him of the termination because that fact was in that notice. So if he did not have that knowledge, he could not have received he could not have received that notice.
I must say this moment council time has expired. And I'd like to thank you both for your presentation today. I thank you both. Please stay well. And hopefully we'll get to see each other in another one of these Zoom conferences or perhaps even in person someday.
Thank you.
Thank you very much, Your Honor.
Thank
Thank you,
you.
Your Honor. Have a wonderful
I will
day.
let you exit or transfer, however they do it. And while you are transferring, we have concluded, panel members, our morning assignment. Do you want to break before we start the afternoon? Or
Just one
proceed?
more. I defer to the panel. I'm ready to go. So